It is case number 108876, 108877, in the matter of E.J.D., a juvenile.
May it please the court, Rhonda Levinson, appearing on behalf of the minor appellant E.J.D. May I request 2 minutes for rebuttal, please, Your Honor?
2 minutes is granted.
Thank you. Briefly stating the facts in this case, E.J.D. was prosecuted under an extended jurisdiction juvenile proceeding. After the imposition of his juvenile and his adult sentences, he was placed in a juvenile facility. The state later alleged that disciplinary violations at that state juvenile facility were grounds to revoke the stay and impose the adult sentence of 94 months. E.J.D.'s defense attorney moved for a durational downward departure of the underlying adult sentence during the pendency of the motion. His allegation was that until the juvenile court's jurisdiction was lifted, that the court had not had the ability to consider a durational departure, but once the adult sentence is imposed and jurisdiction transfers to the adult court, then the court did have jurisdiction to consider the downward departure. The district court found it did not have jurisdiction to consider the downward departure, and there was discussion about whether or not it was timely filed, but ultimately the district court did not reach the...
Doesn't the 382364 provide for a mechanism to ask or to have a downward durational departure? It sets forth that the prosecutor and the attorney for the offender can jointly recommend a departure at that time that the original sentence is imposed. And isn't that specific language contained in the statute?
Yes, Your Honor, that is specific language contained in the statute that allows for a downward departure that's a joint motion. It does not allow for a downward departure motion made exclusively.
And that's fairly specific to this particular scenario. And why wouldn't that specific language then trump the general language that's in the adult criminal code?
Your Honor, I would argue that there is specific language also in the juvenile code that provides that these juveniles, when they're being prosecuted as an adult also, essentially, that they are entitled to all the rights of a criminal defendant. And one of the rights of a criminal defendant is to move for a downward departure. To the extent that the court would find that that specific language controls over the rights of having a criminal defendant in general, I would argue that renders the statute unconstitutional because it violates at that point equal protection and due process. Because I think it's a violation of fundamental fairness to allow only those motions for departure that the state would agree to. Because clearly the state is not going to agree as a general rule to downward departures. For instance, in this case, the boy's 15 years old at the time of the offense. He wasn't holding the paintball gun. He wasn't the person who directly confronted the victim. They got $1 and a $30 cell phone. This is not the typical armed robbery, Your Honor. This is a child in with a group of other children who makes a stupid mistake, and he's going to be serving 94 months in adult prison as a result of that. I mean, in situations like this, the state doesn't agree to a joint motion. And I think that
then why was it, given that scenario, why when the adult sentence was originally imposed, was there not a motion for departure?
Your Honor, at that time, the law of the land was in reg TAL. And in reg TAL, the court specifically found motions for downward departure were not permitted when they came exclusively from the defense. And with that controlling case law on point, the attorney felt that he did not have the ability to file such a motion, I believe, and logically it would follow that he would think that. And therefore, until that juvenile court's jurisdiction lifted and jurisdiction transferred to an adult court such that he has adult penal rights, the attorney thought that that was then the appropriate time to file the motion for downward departure once adult jurisdiction kicked in. Because I think that it is fundamentally unfair and a violation of equal protection to say, okay, if you're 18, you get to file for a downward departure. If you're 17 and a half and you're under extended jurisdiction juvenile proceedings, you can't. I mean, it's a 6-month difference. One person gets to file for the downward departure, the other person doesn't. And there simply isn't a rational basis for a state interest in making that distinction. I think that if you have children in this position where they're being sentenced and prosecuted as both an adult and a juvenile, that to the extent they're being prosecuted as an adult, they are entitled to those rights that an adult would have, which would include, under fundamental fairness and equal protection, the right to a downward departure. I mean, I think that you can view all these statutes in harmony in that, okay, as long as you're a juvenile, you don't have the right to move for a downward departure on your own because we have a vested state interest in rehabilitation and in getting you to comply with your sentence, so we want to have this hammer. There is a rational state interest in doing that. But there's no rational state interest in drawing the distinction between, okay, so you're an adult in this context, but you don't have the rights of the other adults in terms of moving for a downward departure. And as I said, I think that at the time this juvenile was originally sentenced, the law of the land was TAL, which I know that this court is aware, states that downward departures are not allowed. It wasn't until In Re LEM, which was decided in 2008, that this court acknowledged that the juvenile system was changing and that it was becoming more penal in nature and that these children were entitled to more rights. But still at the time of sentencing, TAL was there stating very clearly you can't make this downward departure. And I think it's also significant that it's unfair to the juvenile and to defense counsel to say, well, you should have filed it at the time the kid was sentenced, when even in this context, under the changes in the case law, the district court didn't think it had jurisdiction to have considered it at all, period, end of story, no matter when it was made. So I think that putting defense counsel in a position of having to have guessed that there would be these changes in law and that the courts would consider a downward departure at all is unfair to both the juvenile and his counsel.
So are you saying the juvenile court does have jurisdiction to downwardly depart?
I would argue that based on my reading of the statutes, that until there's adult jurisdiction in the sentencing court, no, because the statute says downward departures have to be made by the...
Well, but you were asking the juvenile court, in this case, to downwardly depart, were you not?
Defense counsel was asking the judge that if the stay is lifted, if the juvenile court is going to transfer jurisdiction to the adult court, then the adult court should consider my motion for a downward departure.
He was asking the adult court to do that.
Exactly.
Because there is language that the ongoing jurisdiction for any adult sanction other than the commitment to DOC is with the adult court.
Yes, Your Honor, and that is our argument.
And if that's the case, then there wouldn't have been anyone up front when the adult sentence was originally ordered that had jurisdiction.
Exactly, Your Honor.
Over that adult sentence.
Yes, Your Honor, that is exactly my argument. That as long as the juvenile court has jurisdiction, it has no power to make a downward departure of the adult sentence or the juvenile sentence. Once the juvenile court loses jurisdiction and transfers jurisdiction to the adult court, and I know it's kind of a semantic thing because it's all the same court, but the reality is they are two separate courts with two separate procedures and separate ways of proceeding and separate rights. So once that jurisdiction ended on the juvenile court and the adult court retained jurisdiction or suddenly had jurisdiction and had continuing jurisdiction, then it did have the jurisdiction to consider this motion for downward departure. And the district court erred when it found it did not have the power to even consider it. So what we are requesting is a remand to the district court to at least allow the argument to be considered and the evidence to be presented. So I think that it's sort of a two-part argument. One, that you can construe all of the statutes in harmony. Nothing is invalid on its face based about these statutes if you interpret them in harmony. That yes, juveniles do not have the right to make their own motion for downward departure. However, once the juvenile court's jurisdiction is lifted, then there's the possibility of this joint motion for a downward departure, but also that the adult rights of a criminal defendant kick in, and the court has ongoing jurisdiction to consider a motion for downward departure at that time in terms of duration. I understand courts have already been ruling that, the type of disposition is no longer within the power of the court, that they must go to prison, that's what the statute says, that's the intent of the legislature. There's nothing in there that indicates a durational departure would be prohibited. He's going to the Secretary of Corrections, he's going to be in prison, but it doesn't mean that this 15-year-old kid who is with somebody else who uses a paintball gun on a bicycle to hold up someone should be in an adult penitentiary for 94 months as a result of something stupid he did when he was 15 years old.
Why wouldn't it be the sentencing court that makes that decision?
Your Honor, I agree that should be the sentencing court that should make that decision. We're asking the court to remand it back to the sentencing court to make that determination. The sentencing court found it didn't have jurisdiction to consider that argument.
Wasn't the sentencing court the one who imposed the sentence at the same time that it imposed the juvenile sentence?
Yes, Your Honor. At the time, under In Re TAL, everyone believed that that court had no jurisdiction to consider a downward departure, durational or otherwise, of the adult sentence. Because TAL was the law of the land, and it had very clearly stated juveniles don't have this right. So therefore, as long as the juvenile court had jurisdiction, it would have found under TAL that it had no power to make this downward departure because the juvenile court still had jurisdiction. I understand it is the sentencing court, but it's the sentencing court sitting as a juvenile court. I think there is some argument to be made that going forward that perhaps it should be allowed that defense attorneys can make a motion for downward departure at the time of the original sentencing. I think as applied to my client in this case, that would be an unfair result because at the time of his sentencing, everyone involved believed there was no jurisdiction to do that under In Re TAL, which I believe was altered by In Re LM. But those decisions following those cases had not yet come down.
Can we move to the next issue, which has to do with what is commission of a new offense or alleged to have committed a new offense? Isn't the evidence here pretty much undisputed that your client engaged in a fight, was the aggressor in the fight? Maybe, but that goes without saying. But was found to have close fist blows to several different victims on several different occasions. Why isn't that establish a commission of a new offense?
Your Honor, arguably these were just minor scuffles. Obviously I was not defense counsel, I did not see the video, but I think the argument is that these are minor scuffles. These are things that this kid was barely punished for at the juvenile facility. He received very minor discipline. If these had been true batteries or true new offenses, that facility would have been locking him down.
Is it enough that there are minor offenses? Doesn't the judge have discretion to set parameters of the conditions, and if the conditions are violated, therefore he can revoke the juvenile jurisdiction?
Your Honor, I think that
I guess my question is, what does it take to commit a new offense? Are we talking about a new conviction, or what are we talking about?
I'm not saying that we're needing a new conviction because it says evidence of a new offense and not necessarily a conviction. That is what the law says. However, I do think it needs to be more than a scuffle in a juvenile facility that's barely punished. I don't think that rises to the level of a new offense. It's not something that anybody would get charged for in real life. It's a couple of teenage boys scuffling.
So your position is that the language "new offense" does not necessarily mean a new crime, a conviction for a new crime?
I would say it doesn't mean a new crime, but an actual conviction. But I would say it needs to be conduct that would rise to the level of a crime that would actually be charged and prosecuted under different circumstances. If you have a couple of boys wrestling around, that's different than something where the prosecutor looking at the videotape would have gone, yeah, I'm going to charge that as a battery. I think you have to have something that would qualify as a crime or an offense against the state before you can revoke the kid based on that.
Any more questions of counsel?
And you're not complaining about the fact that this is all subject to a preponderance of the evidence? In other words, he can be basically convicted of a new offense and by a preponderance of the evidence?
Your Honor, we recognize that the standards are much lower. in the violation cases. That was not the thrust of our argument in this case. Thank you, Your Honors.
Any more questions? Thank you, counsel.
Good morning. Joan Loudon, Assistant County Attorney, on behalf of the appellee. May it please the court. The first thing I wanted to bring to the court's attention that when this case was originally set, and as a result of the EJJP allegations or motions, there was a plea agreement in this particular case. To go back, the state had initially filed a motion to certify EJD as an adult. There were conversations between the parties, and as a result of those conversations, the parties reached a plea agreement, and in September of 2009, the state withdrew the motion to certify. EJD was certified under the EJJP statute, and the underlying sentences for the juvenile case, as well as the underlying adult sentence, was a result of the plea agreement. That's a part of the record, I believe it's volume 3, that the court would have. So what we have is that, yes, the underlying sentence was 94 months, but that was an agreed to sentence at the time that he was initially determined to be or to fall under the EJJP statute.
And how does that impact what we're doing today? Are you saying the statute that precludes appealing an agreed upon sentence that's accepted by the court would apply here?
Judge, I'm not Justice Johnson, I'm not saying that. What I am saying, however, I just want to give context for what this case is about. We are here today and we're talking about the facts and how this particular individual was involved with a paintball gun and ended up committing a robbery with a very low quantity of money. But quite frankly, those particular facts are irrelevant. The issue is whether or not he was able to file a motion for departure once the state had alleged new offenses, had presented evidence that he had committed a new offense while he was at the youth correctional facility.
When could he have filed a motion for departure?
If he was going to file that particular motion, it needed to be filed at the time that the sentencing was imposed. If you look at 38...
When was it imposed?
September of 2009. Well, actually, that's when the plea was entered. He was actually sentenced, I believe it was the following month.
Well, I'm confused because the statute speaks about revoking juvenile sentence and order the imposition of the adult sentence previously ordered. So the statute talks about imposing the sentence after revocation of the juvenile sentence. And I know we have a hybrid procedure here that causes confusion, but I think it's important to look at just when was the sentence imposed.
If you look at the original statute, 382364, at the time that a juvenile is sentenced under an extended jurisdiction juvenile prosecution, the district court shall impose one of the juvenile sentences and impose an adult criminal sentence at the time of the initial sentencing, which is what occurred in 2009. He had the juvenile sentence that was imposed and an adult sentence that was imposed as well. And if you go down further into subsection B, where you get into the revocation or the withdrawing the stay of that adult sentence, excuse me, what it says is that the court shall revoke the juvenile sentence and order the imposition of the adult sentence previously ordered. I think acknowledging back in subsection A2 that there was an original imposition of an adult sentence in September of 2009.
Well, doesn't 283364B explicitly state that a finding of a new offense, which is what occurred here, the juvenile jurisdiction is terminated?
Yes.
So it's terminated.
Yes.
And then why doesn't the criminal code come into play, which allows the district court to reduce or look at a sentence when a non-prison sanction has been violated and a sentence is imposed? That happens all the time, and why, in this instance, is that not permitted?
I think there's two responses to that. One is that the actual statutory language says that once the juvenile court jurisdiction is terminated, that the ongoing jurisdiction for any adult sanction other than the commitment to the Department of Corrections is with the adult court. The underlying adult sentence that had previously been imposed was a commitment to the Department of Corrections. And so you have that language, other than the commitment to the Department of Corrections, which is what EJD had. The second response that I would have to that is that the issue regarding whether or not a juvenile could file a motion for departure at the time that the state was asking for the stay to be revoked has gone up to the Court of Appeals in RLR. Now, that is an unpublished case, but it did go to the Court of Appeals in 2012, and in that particular case, the juvenile in that situation, he was on conditional release, had violated conditional release, had an underlying Department of Corrections sentence, and had argued at the revocation that he should be allowed to file departure motions. The Court of Appeals said in that particular instance that he was not allowed to do that under not only the case law, but they had cited some additional cases as well. So this issue in regards to whether or not he's able to file a motion for departure isn't the first time this issue has come up. And that was RLR in 2012, in which the Court of Appeals held that that was not permissible.
Well, why does a juvenile stand differently than any other person that's facing a sanction or a prison sanction as a result of a non-prison violation of conditions, and then they're facing the court? In every other instance, a person is allowed to ask for a departure, and the judge is allowed to consider it.
And in this particular case, I think had EJD filed a timely motion for departure, that would have been one that the district court could have considered.
And I just don't understand why it's not timely when he's facing that upon the imposition of the adult sentence. Why isn't that timely?
Because it has to. My position is that it has to be filed before the adult sentence is imposed, and the adult sentence had already been imposed. The language of the statute 2364 within the Juvenile Justice Code very clearly states that at the time of the initial sentencing in 2009, he is given both a juvenile sentence and an adult sentence. The adult sentence is imposed and it is stayed.
I think you may be talking past each other. I think Justice Rosen is talking about the statute that deals with the revocation of a non-prison sanction for an adult, that says the judge then can impose the original sentence or any lesser sanction. And I think the question is, when you terminate the juvenile jurisdiction, why doesn't that kick in all of the adult procedures, including the statute that deals with revoking a probation or a non-prison sanction?
And I apologize for misunderstanding your question, but I still would say that 382364 precludes that. When you go to the end of subsection B, where it states that when the juvenile court jurisdiction is terminated, that the ongoing jurisdiction for the adult sanction, other than a commitment to the Department of Corrections, goes to the adult court. And again, in this specific case, the underlying adult sentence was with the Department of Corrections. If you say that once the revocation is held and the court finds by preponderance of an evidence that a new offense is committed, and therefore it just goes to the adult court, which again, as Ms. Levinson pointed out, is an issue of semantics, it can be the same court, then essentially you're rendering that phrase, other than the commitment to the Department of Corrections, useless. It would have no meaning if you just, in every case that there is an underlying adult prison sentence, and the stay is revoked, send that automatically to the adult court without looking at to whether or not there's an underlying Department of Corrections sentence. That language becomes useless. And in order to give that meaning, you would have to look at whether or not there is the underlying adult sentence. In this case, there was, and find that he just be sentenced to serve the underlying adult sentence.
But do you see the irony? If you had been successful in certifying this to the adult court and he'd been given a non-prison sanction, then he would have had an opportunity when he violated to have had a lesser sentence?
Yes.
But since he wasn't certified, he has less rights?
And I understand that is how this works out, quite frankly. Again, this is a situation where initially the state had filed a motion to certify, and it was a result of a plea agreement that he had wanted to do the EJJP sentence as opposed to the adult sentence.
But of course, certification requires judicial action. It wasn't just up to the prosecutor and the defense attorney to work this out.
That is correct. However, I think the court took into consideration that both parties went in front of him and said, we've reached this resolution. We're asking as a result that the motion to certify be withdrawn and this happen. The court in that particular instance did abide by the recommendations presented by both sides in this particular matter. The other issue that I wanted to touch upon briefly is the issue regarding the new offense. There was some question as to whether or not this was a mere scuffle, whether or not it needed to be charged and have an adjudication or a conviction in order for it to amount to a new offense. I think that the district court had the benefit of hearing all of the evidence. There were 6 witnesses that were presented to the district court. In addition, there was video footage, which was very compelling. I have seen the video footage, and I believe that it has been admitted as part of the record on this particular case. And what was seen by the district court were 2 offenses, in April and in June of 2011, where EJD had approached other individuals and had committed battery acts upon them. They were not scuffles, they were not mutual fights. In the 4th volume of the record, there's testimony from eyewitnesses who had witnessed those events. In the first event in April of 2011, the witness, who was a staff member with the youth correctional facility, had described the situation where EJD had knocked another individual to the ground and was standing above him while continually hitting upon him as the other individual was curled into a ball. The second incident in June of 2011 was witnessed by one of the teachers at the particular facility, and she had testified that he had come up, and you can see it in the video of the other individual entering the classroom. His back is, I guess, facing EJD. He comes up behind him. There's no communication or interaction at all between the 2 of them, and he attacks him at that point. EJD himself took the stand when we were doing the revocation, and he had testified that on both of those occasions, neither of the other 2 individuals had ever approached him. What he testified to was that on one prior occasion, the individual involved, I believe, in the April 2011 incident he had one previous verbal altercation with. There had not been any other contact between the 2 of them at the time. And to quote what he had said, I walked up and I hit him.
Here's my problem with all this is that here we have the district court that has imposed a non-prison sanction in a juvenile facility and is able to convert that sanction into a detention into an adult facility for 94 months. A pretty significant change in circumstance, a total deprivation of liberty, and it's based upon an allegation of a new offense. And it seems to me that the juvenile in this case is denied any kind of protection of right to confront accusers, the right to a trial. It's based upon whatever version is presented to the judge, and the judge makes a call that, yeah, a new offense was committed. Therefore, for the next 6 years, you're going to be deprived of your liberty, based upon that. And is that all it takes? Is just an accusation and you put on a few evidence? Can it just take a rule infraction? Is that enough?
You know, that's an interesting question, because when I first decided to file the motion to revoke the stay of the underlying adult sentence, what I was confronted with, and in my motion, which is part of the record, is that during his course at the youth center, EJD had committed 86 violations.
Yeah, let's take any 2 of those. Would that have been sufficient if you had gone to the judge and the judge says, "Yep, those are rule violations, and I'm going to revoke your conditions on your juvenile, and we're going to send you to prison"? Would
I
that have
think
been
case
enough?
law says yes.
Yeah.
I mean,
Any
case,
kind of violation, even if it wasn't a crime, defined as a crime.
What? And this is where we kind of get into the distinction between violating the terms of the juvenile sentence and creating a new offense. Prior to this case, to my knowledge, all of the other cases regarding the EJJP statute have dealt with situations where the juvenile is alleged to have violated the terms of the juvenile sentence. Namely, all of them have been either on probation or conditional release. They have their list of terms that they go through an initial when they first start, stating that they're not going to hang out with people who are on probation, that they're going to abide by the law, they'll maintain a curfew, they won't drink, things of that nature. And there's a list, and they go through and they initial each one, and at the bottom of it they sign it. And it's kind of a contract, if you will, regarding what's expected of them while they're on probation and what's expected of them while they're on conditional release. So when this particular case was presented, and I saw that there were 86 violations, what I didn't have was a signed contract. And so I kind of had to make that analysis at the time that I filed the initial motion to revoke the stay of the underlying adult sentence. The fact that he had 86 rule violations, would that amount to, despite the number of violations, despite that some of the violations would have been considered crimes, would that have fallen and met the standard of violating the terms of the juvenile sentence? And so, because of the evidence in these particular two cases, and because they were very clear battery cases, I opted to go through and allege that he had committed new offenses. Because I didn't have the signed conditions, and in addition because they were codified criminal activity. It was something that I could point to and say these acts amounted to something that constitute a battery, which is a violation of state statute,
So why
and
didn't you
therefore
file
would be a new offense.
So why don't you file a battery case, and then you have alleged to commit a new offense? You have a trial or whatever comes of that, and then you have your new offense.
Because that changes the standard. In order for there to be an actual adjudication or a conviction, the standard is beyond a reasonable doubt. That's what would have needed to be shown in order to get that conviction or adjudication. But when you look at this particular statute, 2364, the standard is
Right. It is preponderance of the evidence.
Preponderance of the
It is.
evidence.
Yeah, I understand.
So in order to, if you say that there has to be a new conviction or a new adjudication, or it has to be charged, in a sense, you're saying that the standard is wrong and that you want to change the standard.
Then what's the distinction between those two ways of terminating the juvenile jurisdiction? The violating the sentence and evidence of a new offense. Mm-hmm. The way I hear you explaining it, there's really no difference.
Well, I guess I would argue that I think there is, which is why I opted to allege that the new offenses had been committed. When you look at violating the terms of the conditions of the juvenile sentence, again, all the other cases deal with that, and that's when they are on probation or conditional release. We have some cases where the juvenile was on probation, he had absconded, he wasn't where he's supposed to be, he had potentially used alcohol, I believe it was, or things of that nature. Not being where you're not supposed to be is not a codified criminal activity. I would not constitute that as a new offense. It violates the terms that he's supposed to be abiding by, the terms that he signed off on when he was placed on either probation or conditional release, but it's not a new offense. So I think that there is a
Sometimes they call them
distinction.
technical violations.
Right.
Don't those lists often include shall not engage in any further criminal activity?
Yes,
And in that case, they'd be the same.
yes. Although in this case, I didn't have that because he was at the youth correctional facility. So there wasn't any signed conditions that he had in this particular case.
Right, he wasn't on conditional release already.
Right. I see that I'm out of time. If there are no further questions, I have no further comments at this time.
If, in the hypothetical you presented, he was on probation and he had signed the terms and conditions document saying, I promise to obey all these terms and conditions, and then he engaged in some conduct that you might consider to be a criminal offense, what would be your obligation as a standard to meet in order to prove that he had violated the terms? Is it a preponderance of the evidence, or is it beyond a reasonable doubt, or something else?
In terms of the EJ, in terms
The
of
hypothetical
2364,
we were talking about, you're making an analogy to someone who's on probation, I believe.
well, in 2364, regardless of whether it's a new offense or a technical violation, if you will, the standard remains the same as preponderance of the evidence.
even if we were not talking about this different type of jurisdiction, is my question.
Okay. It is not beyond a reasonable doubt. I believe it is preponderance of the evidence, but quite frankly, I would have to look at that statute. I don't know off the top of my head.
For juveniles as well as adult offenders?
I believe
If
so,
you-
yes.
All right, thank you. Any further questions?
Chief, I do have one. That raised a question. In the facility where these offenses took place, was there a grievance procedure? Was there any type of due process going on there? Or was that just, I find that you're fighting, you're in violation of the rules of the detention facility?
Generally, what had occurred was when there were rule violations, I mean, they were made aware of the rules, my understanding is upon entering the facility. However, I don't believe that, as in probation or conditional release, they sat down and had them initial and sign off on, I understand these are what the rules are. When a rule is violated within the youth center, as was this case, there are internal disciplinary proceedings.
So there is some type of a grievance board within the facility?
Yes, and actually in this particular case, the two individuals who had heard the disciplinary hearing on EJD for the acts of April 2011 and June 2011 did testify at the revocation regarding their policies and procedures, what had occurred with the specific instances of EJD. Yes.
Any more questions? Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
Thank you, Your Honor. First, in reference to RLR, I believe that unpublished decision is, first of all, wrongly decided, and second of all, not really relevant to this case. That case hinged on the part of the statute that talks about the court has continuing jurisdiction for everything other than commitment to the DOC. In this case, we're not arguing he should be on probation. The argument below and the argument now is that he should be entitled to at least consideration of the mitigating circumstances to shorten the time that he's staying in the DOC custody. We acknowledge that, yes, he had these issues that, and we argue are not sufficient to rise to the level that it needs to revoke him from the juvenile sentence, first of all. But even if it is, he should be entitled to a time at which he gets to present evidence and mitigation and make a motion for downward durational departure. So that what we're arguing for in this case does not render that portion of the statute useless, as the state alleges, because we're not arguing about the other than commitment to the DOC. We're arguing how long should he be at the DOC. So that is really the thrust of our argument, and there's just no rational basis.
So excuse me, just so I make sure I understand your argument. So the length of the commitment is not part of the commitment over which the adult court has jurisdiction, or excuse me, the juvenile court retains jurisdiction?
Well, the statute states that the adult court has continuing jurisdiction over everything other than commitment
Other
to the
than
DC.
that, so we presume that jurisdiction remains in juvenile court? That piece?
I think the argument around RLR was that the court didn't have the jurisdiction not to send him to the DOC. In other words, the court lacked the power to put him on probation, but that's the only piece of jurisdiction that the court lost. And I think that is the rationale behind that line of cases, which I think is wrong, but also not applicable in this case. That you're setting attorneys up for malpractice or ineffective assistance of counsel claims if you try and say, oh, you should have done it back in 2009 when this came up and the sentence was originally imposed, because TAL said they couldn't. So the juveniles are in this situation of they're not supposed to be able to make this motion as juveniles, so logically they should have been able to make it once the juvenile court jurisdiction ended, because it's just fundamentally unfair to treat similarly situated defendants differently.
Do we have any more questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.